the state has launched an application for a referral of the accused for observation in terms of Section 79 of the Criminal Procedure Act 51 of 1977, the Act. The application is brought in terms of Section 78, Subsection 2 of the Act. Counsel for the state referred to this court to a number of cases which I found very useful. Strangely, the application is opposed on behalf of the accused. Section 78, subsection 2 reads as follows. I quote, "If it is alleged at criminal proceedings that the accused is by reason of mental illness or mental defect or for any other reason not criminally responsible for the offense charged, or if it appears to the court at criminal proceedings that the accused might, for such a reason, not be so responsible, the court shall, in the case of an allegation or appearance of mental illness or mental defect, and may, in any other case, direct that the matter be inquired into and be reported on in accordance with the provisions of Section 79, close quote. It is clear from the wording of the section that the key words are, if it is alleged or if it appears that due to mental illness or mental defect, the accused might not be criminally responsible, then a referral is in order. The language of the section is peremptory, as was set out in S. v. Mukhorosi, 1979, Volume 2, SA 938, capital A in bracket, at 941 G to H. I quote, Section 72, subsection 78, subsection 2, enjoins a court in peremptory language to direct that the accused's mental condition be inquired into when either of the following requisites is present. Firstly, if it is alleged that the accused is by reason of mental illness or mental defect not criminally responsible for the offense charged, or secondly, if it appears to the court that the accused might, for such a reason, not be so responsible, close quote. It is clear that counsel for the state was correct when he submitted that the court has no discretion once either of the two requirements has been met. The trigger to the application was the evidence of Dr. Merrill Foster, a forensic psychiatrist, called on behalf of the accused. Counsel for the state submitted that it was clear that the evidence of Dr. Foster that the accused suffered from a generalized anxiety disorder at this stage of the proceedings was calculated to make up for the accused's bad performance as a witness. He submitted that the fact of the evidence of Dr. Foster may become important should the court reject the evidence of the accused, hence the application for referral. In opposing the application, counsel for the defense submitted that there was no allegation as envisaged in the Act, or if there was, it was not substantiated. He submitted further that it did not appear that at the time of the incident, the accused was not criminally responsible. For these reasons, he argued the application could not succeed. It is so, as counsel for the defense argued, that a court does not act on a mere allegation of criminal incapacity without some indication of the reasons therefore. In brackets C.S. v. Makoka, 1979, Volume 2, 933, capital A in brackets. I, however, do not agree that in this case there are no allegations. The accused may not have raised the issue that he was not criminally responsible at the time of the incident in so many words, but evidence led on his behalf clearly raises the issue and therefore cannot be ignored. Not only that, but the allegations have been properly substantiated by the evidence of Dr. Foster. Dr. Foster compiled a comprehensive report detailing the accused's developmental history, which included social and professional relationships and how they shaped his personality. She also dealt with past medical history, past psychiatric history, habits, history of the incident, mental state evaluation, and psychiatric diagnosis. Her focus was on her diagnosis and her findings that the accused suffered from a generalized anxiety disorder which may have affected his conduct on the 14th February 2013. She repeated this under oath. To fully understand the significance of Dr. Foster's evidence, it is necessary to focus on extracts which I think are of some relevance. Dr. Foster mentioned, for example, that the accused, amongst other things, was hypervigilant. When asked what she meant by that, she stated, I quote, "Hypervigilance is somebody that is overvigilant, so they're constantly looking around, scanning their surroundings for any kind of threat, and generally not able to relax," close quote. When dealing with the history of the incident, Dr. Foster's opening remarks were the following. Mr. Pistorius relates that he believed he had an intruder. He became scared and he describes having had escalating levels of anxiety, close quote. Counsel for the defense asked, any relevance in the physical vulnerability in relation to his anxiety? Dr. Foster's response was, I quote, "I think they go hand in hand, my lady. His physical vulnerability makes him more anxious. His anxiety makes him want to conceal his physical vulnerability," close quote. Dr. Foster stated more than once that the accused has a long history of generalized anxiety disorder that appears to have been increasing with time. She set out a number of factors which were responsible for increased level of anxiety and then stated the following, I quote, "These factors were all operating at the time of the offense under discussion and would have been compounded by Mr. Pistorius' physical vulnerability and the additional pressure of perceiving his environment as hostile and unsafe. When exposed to a threat, Mr. Pistorius is more likely to respond with a fight response rather than a flight response, as his physical capacity for fight is limited," close quote. Explaining what was meant by a fight or flight response, Dr. Foster said, I quote, "This is a response that protects us and helps us to keep us safe. So when exposed to a threat, we can either fight or flight, depending on our own personal circumstances. And in Mr. Pistorius' instance, he would have been more likely to fight as his capacity to flight was compromised. In my opinion, Mr. Pistorius' reaction to the perceived threat during the incident of 14 February 2013 should be considered in the light of his physical vulnerability and his comorbid diagnosis of generalized anxiety disorder, close quote. When asked to elaborate, Dr. Foster mentioned two aspects that would have been operating at the time of the offense, namely, one, the accused's physical vulnerability. As an amputee, the accused's capacity would have been compromised and he would not have been able to get around easily. And two, the accused's generalized anxiety disorder, I quote, which was pervasive and had been present for many years, which would also have been present on the day of the offense, close quote. Although Dr. Foster stated that she did not think that a generalized anxiety disorder was a mental illness, for purposes of the Act, she stated the following, I quote, "I think it is clear that Mr. Pistorius has a psychiatric illness. He certainly was able to appreciate the difference between right and wrong, but it may be that his ability to act in accordance with such appreciation was affected by this generalized anxiety disorder." In the face of the statement above, a debate on what exactly the generalized anxiety disorder really is or where it would fit in the Act would be a fruitless exercise. I say this inter alia because nowhere in the Act is there a definition of mental illness or a mental defect. There is, however, an indication from case law that it would be unwise for a court to attempt a diagnosis without assistance from the relevant experts. Mental illness and mental defect are morbid disorders that are not capable of being diagnosed by a lay court without the guidance of expert psychiatric evidence. In brackets, CS versus Mabena and another, 2007, Volume 1, SACR 482, in brackets, capital SCA, close brackets, at 486, paragraph 16. In the present case, Dr. Foster's evidence was placed before court by the defense. The effect of the evidence is that a doubt has been created that the accused may possibly have another defense relating to his criminal responsibility. There is also a possibility that there may be diminished criminal responsibility. The evidence of Dr. Foster has not been contradicted, nor can it be in the absence of other psychiatric evidence. This court, as a lay court, is ill-equipped to deal with the issue raised in Dr. Foster's evidence at this stage. The allegations in the report of Dr. Foster and the views expressed by her have substance, and what is more, they are in line with the accused evidence. That in itself is significant. Dr. Foster's report, however inclusive it may be, cannot replace a proper inquiry made in terms of the Act. Among other things, Dr. Foster had only 2 interviews. During the interviews with the accused, the duration of the interviews with the accused is not stated, while it appears that she may have had very little time in which to compile her report. A proper inquiry, which would be more comprehensive, would, inter alia, in my view, ensure that the accused gets a fair trial. Counsel for the defense submitted that the application for referral was premature, as he intended to call another witness who would give evidence on the fight or flight response. This witness would explain the concept in detail, he argued, and if the state still wanted to make the application after that evidence had been laid, then it could do so. In my view, the question is whether the applicant, that is the state in this case, has made out a case for the relief that is sought at this stage. If it has, I fail to see what the evidence of this other witness would be, or how it would assist this court to determine whether a referral as sought by the state is warranted. Counsel for the defense submitted further that the cases that were cited to this court were distinguishable from the present case, and that in most of them it was clear that there should have been a referral, while in the present case there is no substance to the allegations. The cases may indeed be distinguishable on the facts, but there is the required substance in both the report and the evidence of Dr. Foster. And as I said earlier, this cannot be ignored. In any event, the test remains the same, irrespective of the circumstances of the case. The question is whether there was a reasonable possibility that a referral of the accused for observation in terms of Section 79 of Act 51 of 1977 would reveal inter alia that at the time the crime was committed, the accused suffered from a mental disorder which could have resulted in his not being criminally responsible for his act. Having regard to the facts of this case, I'm persuaded that the requirement of a reasonable possibility has been met. It is so, as counsel for the state submitted during argument, that a referral inevitably means more delays in finalizing this matter. But this is not about anyone's convenience, but rather about whether justice has been served. It is necessary to emphasize that an application of this nature is never taken lightly, as it is an integral part of a fair trial. Having regard to the above, I am satisfied that a case has been made out for the application or the relief as sought by the state, and I shall grant that order. However, the specific order itself will be handed down on Tuesday next week.
As the court pleases.
As the court pleases, my lady.
Before I adjourn, is there anything that counsel might want to?
Well, lady, we have agreed between myself and Mr. Roux that we will assist the court in preparing the order, and that we will have the order available and ready by Tuesday morning. We will meet and assure the court that we agree on the specific order and that it could be made on Tuesday. There are various administrative issues that need to be considered and dealt with in this time, but we will have enough time, my lady, to deal with all those.
Thank you. Mr. Roux?
That is indeed correct, my lady. We undertook, because we know about the time delays in the event of a detention that we have discussed, the so-called outpatient basis in the Volkman case. I don't anticipate any difficulties on that, but we will prepare a proper order for the court's consideration, and also what we believe should be on the panel, like also not only 3 psychiatrists, but possibly also psychologists, but that's in Anne's court. But we will make recommendations to the court and in our draft for the court then to consider and accept or amend.
Thank you very much.
Thank you, my lady.
Yes, I just want to place on record that it is, I'm glad counsel agreed on this. I think it should be borne in mind that the aim of referral is not to punish the accused twice. So if there is a possibility of making sure that he's an outpatient, I think that would be preferable.
It will be investigated.
Yes. Thank you very much. We'll adjourn until Tuesday. What's the date?
20th of May, Malaysia.
20th of May.
Yes.
At 9:30 in the morning.
As God pleases.
Thank you.
Are you all right?